and highlighting promising practices to support court attendance and aim to prevent and clear warrants. We're focusing on this topic because we know that missed court appearances often lead to further warrants, avoidable pretrial detention, and further racial disparities within arrests and jail admissions. For today's agenda, so you all know what to expect for this program, we'll be starting with a presentation by our colleagues at Ideas 42, and that will be followed by a presentation. That presentation will be followed with a discussion from our esteemed guests, Karen Kane, Jamia Steele, and Judge Courtney Wackel, who are implementing distinct approaches within their jurisdictions to further support individuals to return to court. Throughout today's discussion, there will be a Q&A option which is available toward the bottom of your Zoom screen. If you have a question, please feel free to enter that question, and we will have an allotted time later in the program to respond to audience questions. So please, as we go through today's session, enter the questions that may come up. So to get started with our program, I'd like to introduce Alyssa Fishbane and Samantha Hammer. We're joined by them from Ideas 42, where Alyssa is a managing director and Samantha is a principal behavioral designer. They've led Ideas 42's partnerships with courts using behavioral science to lower barriers to court appearance and help more people make their court dates and move cases forward smoothly. They've recently completed an expansive review of the research on what practices move the needle on court appearance, and they'll share their insights into what often leads people to miss court and the leading strategies that courts can use to increase their appearance rate. I'll pass it off to Alyssa.
Thank you, Crystal, and thanks to everyone who's joining us today. So as Crystal mentioned, we'll be talking at a very high level about the different proven and promising ways that courts are increasing appearance across the country. And our panelists will dive really deep into some of these practices. We'll also touch a little bit on the issue of court appearance and the problem itself, because oftentimes it's not fully understood. And if we want to solve this problem, we really need to understand the details of it. So, I'm Alyssa. My colleague Samantha will be joining me for this presentation, and we'll start by quickly aligning on why court appearance is so consequential. Both people and the courts want to move things forward. They want to be, resolving their cases, and there are a number of reasons it's consequential, and here are three big ones. First, missed court dates are a primary cause of arrests in jail. So there's data around the country, the Jail Data Initiative. If you look at, different counties, the top bookings include missed court appearances. In Michigan, for example, the leading cause of arrest above DUI, above simple assault, is missed court dates. So if we want to limit pretrial detention, we really need to be looking at this problem. The second is missed court dates are costly. Warrants in jail, suspended licenses, all of these are very costly for people, for their jobs, their stability, their families, their housing, and also the system itself. An outdated number is over $1,100 per missed court date costs for courts. That easily adds up to tens of millions of dollars in jurisdictions every year. And this doesn't include costs for attorneys, for arrests in jail, which add up to even more. Missed court dates also widen racial inequities. So, simply put, Black individuals are punished far more for non-appearance than white individuals. For example, recent data in St. Louis shows that among people issued bench warrants, Black individuals are arrested at 4 times the rate as white individuals. So we really want to be addressing this issue both from the perspective of the system, the people in the system, and our communities. So let's look, excuse me, my computer's acting up a little bit. There we go. So let's look first of all at why, what's behind this court appearance and what's causing it. And I think one of The biggest and most pervasive myth that we have is that people are intentionally missing court, even though the evidence, is overwhelmingly showing that willful flight is rare. Most people are showing up to court, and if they miss it, they are coming in, soon. Very few, 3% of those on felony charges across the country are still outstanding after a year. Our research, we see with others' research, when we talk to court users, they talk about the great effort they go through to get to court, sometimes successful, not always, unfortunately. Yet, despite this abundance of information showing that, people really do try very hard to get to court and intend to go, we still have this image often of when people miss court dates, we have this image of this guy running from justice. And this is what got us interested in thinking about the problem of court appearance from the perspective of behavioral science. At Ideas 42, we use the insights from the science of human behavior for social good. We're a nonprofit, and 9 years ago, we started looking at this problem, asking ourselves, what can psychology, what can good design do to help people show up and avoid these consequences? Now, one of the reasons that this myth is so pervasive is our basic assumption about human behavior. We have this assumption that people's actions are based directly on their intentions, that there's a direct link. If you intend to go to court, you will show up. Yet if we look within ourselves, we often see that this just isn't exactly the case, right? So if you think about things that we often intend to do, maybe it's, I'm going to exercise more this week, or I'm going to eat healthier, or fill in the blank. We often fall short of those actions. And so if we look at the real reason, the real reality of the model of behavior, it looks a little bit different, where between the intention and action is the environment people are in. The features of their context or situation which either enable them to follow through in an action or cause these barriers and prevent them to follow through. And this is really important because without understanding this context, it's really hard to understand which solutions are going to be effective. And unfortunately, much of our legal system, not all, and many of our court processes often are designed for two different extremes, two different types of people. One, when we create these processes, we often are imagining someone like Spock. You can imagine, it doesn't matter how unclear or confusing the information we may give the person, they're still going to show up. It doesn't matter what's going on in their life, they won't forget, they'll show up, right? So they're almost like a machine. On the other hand, we sometimes go to the other extreme and design our court processes for someone like this guy. And assuming if someone's not exactly perfect across the board, that they're intentionally evading the law. And behavioral science gives us, really the truth about behavior, which is that people going to court are just people. They're not automatically perfect, yet neither are they trying to game the system. So with that, we can start digging into some of the real reasons why people are missing court. And for that, I'm going to hand it over to my colleague, Samantha.
There we go. Thanks, Alyssa. And yes, I will start by sharing some of the takeaways about common reasons that people miss court, and some of which might not be so obvious. So we know that by talking to court users and the data on why people miss, that everyday life and hardships create some real concrete and visible barriers that get in the way of people coming to court. So there are resource gaps like lack of transportation, health challenges, there are inflexible work schedules that people deal with, and the others that you see here. And we know that court users who have less wealth and less access to resources are more likely to be affected by these barriers. So this list that's on the screen here, probably a lot of it looks very familiar to people who work in the courts, but these aren't the only barriers that are important. So in our research and others, we've seen behavioral barriers that play an important role as well. And there are 4 big ones that I want to touch on here. The first is the mental impact of scarcity on those experiencing poverty, which makes it really harder to take the steps needed to get to court. And I'll talk about that more in a minute. The second is the overwhelming fear that people often feel about going to court, fear that they might be arrested unexpectedly or given a fine that they can't pay, or just even the fear of the unknown. And coupled with that, a feeling of distrust that many feel about how the court may treat them. And these emotions can be really powerful inhibitors from coming to court. And we see this again and again. Third, unclear and hassle-filled processes that people might encounter. Things like confusing forms and difficulty getting help from a real person. They can cause court users to make mistakes or to procrastinate or just to give up on the process altogether. And then also simple forgetting, as we all do from time to time. Just as people forget, important doctor's appointments, and we can forget important meetings at work, we can also forget a court date, even if we think it's important. So these behavioral barriers, we've seen them all be really important, but we want to talk a little bit more about scarcity today because it's less well known and it tends to magnify all of these other barriers. So the big takeaway about scarcity is that when key resources are in short supply, we tend to focus in on what is urgent. And to talk about scarcity, first we need to talk about this thing called cognitive bandwidth. So cognitive bandwidth is what controls our ability to do executive type thinking. So key things like focus our attention or remember what we plan to do. And unfortunately for all of us, we all have limited cognitive bandwidth. And also, unfortunately, it gets depleted pretty easily by things like having to make a lot of decisions or manage stress. And when our cognitive bandwidth gets depleted, we lose our ability to do these key mental tasks effectively. So we're more likely to make mistakes or get distracted or only focus on the present. So just think for a second about how you feel at the end of a long, busy workday when it feels like you can't possibly make another decision or you can't take in any new information. It's because your cognitive bandwidth is depleted and you need to recharge it with rest. Now, a big thing that zaps our cognitive bandwidth is when we're experiencing some form of scarcity. So scarcity is when some vital resource like food or time or money is in short supply. And research has found that when we're experiencing scarcity, we focus all of our cognitive bandwidth on trying to deal with it. So it's akin to being under a tight deadline when all you can think about is what you have to get done, and you're experiencing a lot of stress, and the focus of putting your mental energy toward that deadline can be really exhausting. And this is true for everyone. We all have this response to scarcity, and it can be really helpful when we are in situations where we need that intense focus. But what about when the experience of scarcity continues for days or months or even years? Then we're talking about chronic scarcity, which is what people living in poverty are experiencing. So when you're experiencing poverty, your bandwidth is depleted all the time. For instance, you have to do a lot of trade-off thinking and planning to make the money stretch, and all of that trade-off thinking uses cognitive bandwidth. And because there's no break from poverty, this cycle tends to continue. The more you focus on dealing with the scarce resources, the less bandwidth you have for dealing with other things, even important things like court appearances. So it's like being under a tight work deadline all day, every day. To put it another way, research has found that for people who are already experiencing financial hardship, just having to think about how they would handle a major unexpected expense takes a hit on their cognitive bandwidth that's equivalent to missing a full night of sleep. And add to this, a growing body of research is also showing that experiences of racism may have a similar effect on cognitive bandwidth, exacerbating the impact of scarcity. So all this tells us that we can expect that court users who are experiencing scarcity in some form will face higher barriers to navigating court processes. So what may seem like relatively simple steps, like remembering a court date, filling out a form, become harder because of the depleted cognitive bandwidth. And so the takeaway for us is that since many court users are likely experiencing scarcity in one form or another, this is really a key barrier for folks working in the courts to keep in mind. So if these behavioral barriers and the other barriers that we've named are the real reasons that most people who miss don't make it to court, it's clear why relying solely on warrants to encourage appearance doesn't work. And in contrast, courts around the country are seeing real gains by finding ways to lower these barriers to appearance. And by doing that, they're helping more people successfully navigate the pretrial process while on release, and they're able to move the cases on their caseload forward more efficiently. So it's really a win-win. And when our team at Ideas 42 started exploring the science of court appearance more, we saw how hard it was to find out, what court's doing what, and to find good data on what increases appearance rates. So as Alyssa said, we did a big sweep of the existing research, and we talked to folks around the country working in courts, and we identified and selected the practices with the best evidence and the most promise, and we collected them into our new National Guide to Improving Court Appearances as a resource for the field. So we'll put a link to that in the chat. And I'll talk through the big findings from that work and some of the key examples today, but there's much more in the report. I'll start just by giving a bit of a framework here. We saw that the practices that have the best evidence or that most directly target the barriers to appearance tend to fall into at least one of these 4 buckets. So they make pertinent information about the court appearance clear, timely, and accessible. They reduce the logistical hassles that people have to deal with in order to appear. They add flexibility into the process, or they provide useful resources for those who need them. So to improve appearance rates, courts can focus on working toward these 4 goals. And I'll share a little bit more about what each of these goals looks like in practice before we can hand it over to our panelists to share their experience with some of the leading practices. So first, make information clear, timely, and accessible. So this tweet really struck a chord because it illustrates just how critical court communications are and how so often those communications can be a weak link. It says, mail is cool because 99% of the time it's a JCPenney catalog for a previous tenant, and 1% of the time it's something that you'll go to jail for if you don't look at. So court appearances shouldn't be a surprise, and figuring out how and when to show up shouldn't be a puzzle for court users. But too often that's what happens because the information that people get about their court dates is confusing, or the key details are hard to find, or the information just simply doesn't get to people at all. So improving communications is really a foundational strategy for any court. For one, it's strongly backed by the research. Communications interventions have been shown to improve appearance rates by up to 36%. It's often highly cost effective. For example, redesigning forms can cost little or nothing, and text message reminders can be cheap to run after an initial investment. And it's something all courts can do. So all courts have communications they use and have opportunities to improve, and even small improvements can go a long way. And there are also lots of opportunities throughout the pretrial process to make sure that people have the information that they need to act. So the 3 most successful practices that we found courts using to improve the information that people have about their court dates are these. First, redesigning court forms. So this can include things like citations or notices of next court date and others. And this is a really great place for courts to start because any court can do it. As I said, it's no or low cost, and there are relatively simple strategies informed by behavioral science that can make forms much more effective. Also, court date reminders, just like we all now expect from our doctors and our hair salons, these can be sent prior to the court date and afterwards, including after a missed hearing, to make sure that people can remember and have the pertinent details about when and how they need to get to court. And these can be sent in a few different ways, via text, call, email, or mail, or best, some combination of these 4. And evaluations across jurisdictions have found reminders improving appearance rates by 4 to 26%. And last, post-arraignment meetings. So this is based on an interesting pilot project in New York City where people at higher risk of not appearing were invited to a voluntary meeting with court staff immediately after their arraignment. And in that meeting, they talked quickly through just next steps in the process and made sure people had a plan for returning to court. And then those folks also received a reminder call prior to their next court date. And this as a whole was found to reduce non-appearance during the entire rest of a person's case by 32%. And just to give an example of using redesigned court forms and reminders from our experience, our team at Ideas 42 collaborated with New York City to redesign the citation that people received for low-level offenses. We using behavioral communication strategies. And then also we developed behaviorally informed text message reminders that were sent prior to the court date. And we evaluated both of these interventions and found that the improved citation reduced non-appearance by 13% and the reminders by another 26%. And the reminders, interestingly, were in particular most effective among people living in low-income neighborhoods. So combined, these interventions avoided over 30,000 warrants, and also they were low cost to implement, so they saved the city a significant amount of money. And we're lucky to have Karen Kane with us on our panel today. She'll be able to share more about the reminder program and the great ways that New York has expanded that since. Oh, sorry. All right, the next goal is to reduce logistical challenges. So even though the appearance itself may only take a few minutes, showing up to court can take a lot of time and effort from court users, especially for those experiencing scarcity. And so the goal for courts can be to make showing up feel less like arriving at a crowded airport where it's impossible to figure out where to go or it takes forever and you come out the other side exhausted and frustrated, and more like zipping straight through TSA PreCheck. And some of the leading strategies that can make the process more streamlined include virtual appearances, which cut through many barriers having to do with getting to court in person, like lack of transportation or needing to take hours off of work, but also the fear of going to court in person. And the pandemic showed that virtual hearings could be successful and that many court users actually preferred them. And though we don't yet have rigorous studies, there are really strong indications that people appear virtually at higher rates. Also, streamlined warrant clearing strategies or processes. So prior warrants for failures to appear can be a big barrier for people going to subsequent court hearings because they're afraid to contact the courts. They don't know the next steps to resolve a warrant. And so this can snowball and cause people to miss more and more hearings. So simple processes that let people clear warrants for non-appearance and for similar low-level things can remove that barrier. And these processes can take different forms, but overall they are most effective if there is a guarantee that people can't be arrested while trying to clear a warrant to really be able to reduce that fear. And we'll be able to hear about two really exciting approaches to warrant clearing from our panelists, Jamia Steele and Judge Wackel, a little later. And then an obvious but often overlooked strategy is to just have fewer appearances where the court user is required to appear. So often hearings are for procedural matters, that court users don't really need to be at, and courts can limit the required hearings to substantive ones and make others optional for court users. And this makes the process easier, and it also signals respect for the court user's time. All right, the third goal is for courts to add flexibility into the process. So we know that like with any appointment, things are going to come up that make people miss court. They might have an emergency or get stuck in traffic, or they just aren't able to take time off of work. And appearance times that are set by the court and penalties that kick in immediately after a non-appearance just don't allow any room for human error or for the unavoidable. And this can be especially difficult for people dealing with scarcity who don't have the resources to, for instance, pay for a car if they're running late, and who can't afford to miss a day's pay. Courts can respond by giving people slack when needed. So for one, courts are allowing court users to schedule their own hearings for certain appearances, and also to reschedule a hearing once or twice during a case. So for example, the Salt Lake City Justice Court allows people charged with traffic offenses and certain misdemeanors to schedule their own arraignment, either online using Doodle or by calling the court. And if they don't schedule it, the court goes ahead and sets the court date, and so things proceed as normal. But the court estimates that about half of those who are eligible to schedule their own arraignment do so, and that those self-schedulers have a really high appearance rate. The court has estimated it can be up to 98%. And then another way to create slack is to have a grace period to give people who miss an opportunity to show up before a warrant is issued. So some grace periods are set by statute and others are set by the court. And these can vary a lot in length. So for instance, Georgia and Nevada offer 30 days for a missed traffic appearance. In other places, the grace period might be until the end of the week or just until the end of the day. But an interesting new statute in New York State provides for a 48-hour grace period after a missed appearance. And importantly, it also requires that the court notify the court user, or at least their attorney, so that the court user should be aware that they have missed a court date and also have instructions about what to do next. So this went into effect recently, and it'll be really interesting to see the impact when there's data available. All right, the last goal for courts is to provide useful resources for those who need them. So earlier we looked at a long list of barriers to appearance that included many resource gaps, as well as serious challenges folks might be facing. And of course, the courts can't solve all of the larger systemic issues around wealth inequity or unequal access to healthcare, but they do have the power to take steps so that people with less don't have to shoulder such undue burden to get to court. So on the one hand, courts can help provide some of the basics that people need to participate in the pretrial process and help to kind of level the playing field. And this can include material support that could look like funding or other help to make transportation available, or also similar help with childcare. But it can also include support just for the pretrial process itself. So for example, making sure that people who are not in a position to hire their own defender have quality representation at an early critical stage hearing, ideally prior to their first appearance before a judge. And on the other hand, so in kind of this other type, court users with larger challenges, like folks dealing with homelessness and addiction or significant mental health challenges, they're likely to need different approaches to be able to navigate the pretrial phase. And courts can put in place more intensive support or other options for them. So a leading model in general is wraparound services with case management. And this is a broad umbrella category of practices, and it looks different in different places. But in general, it aims to address court users' immediate needs so that they can prioritize their appearances, and provides other supports that reduce the mental and financial and logistical burdens of showing up to court. Another approach for folks with higher needs is diversion, with the goal of really reducing their obligations to the court and getting them connected with resources or services to help address the underlying issues that likely contributed to their contact with the criminal legal system in the first place. And so this is a very high level kind of overview of this strategy, because with all of the practices around providing resources, the context and the specific ways that programs are matched to needs really matter. And also in general, the research into the impact on appearance rates is less robust at this stage than it is for the practices that focus on, say, approving information. So there's really a lot more nuance here than we have time to get into today. And I encourage folks who are interested in this strategy to check out our report for more specifics. All right, I know I'm coming up on time, and I want to wrap up by spending a minute on a couple commonly used strategies that have been found to not have a strong impact on appearance rates. So these might seem intuitively like they should work, but the research tells a different story. So the first is electronic monitoring, or EM. A recent study looking at EM in 4 different jurisdictions across the US found that it did not lead to an increase in appearance rates. So they looked at a group of folks assigned to monitoring and a group that was not in each of the jurisdictions, and saw that about 86% of court users in each group made all their appearances. Past studies as well have had some mixed results, but generally point to the same conclusion. And in fact, some prior research has found that people on EM may have higher rates of non-appearance. And there's a similar story with drug and alcohol monitoring as well, and that includes drug testing and drug and alcohol monitoring devices. So that same study of 4 jurisdictions additionally found no increase in appearance rates for those who were on drug and alcohol monitoring or testing. So around 77% of court users in both groups made all their court dates. And this is also in line with prior research, which has found no clear evidence that pretrial drug testing improves court appearance, and that testing may even worsen non-appearance rates. So these findings just really raise questions about ways that both kinds of monitoring may actually raise barriers to appearance. So for instance, might create more opportunities for violations, may increase folks' fear, or it might just be creating additional obligations like needing to get a device fitted and adjusted that create more chances to miss court. Also, both these practices are costly for jurisdictions, and the costs are often passed on to court users who can generally ill afford them. And there might be knock-on consequences for court users as well, like losing out on jobs because they're wearing a monitor. So without getting into the other reasons why jurisdictions may choose to use these strategies, just purely looking at them as a way to encourage court attendance, the research doesn't point to a clear benefit. And so jurisdictions should think critically about when and how they're using them if they choose to do so. All right. So for a much deeper look into the strategies that I've talked about and others, folks can download our guide to improving court appearances. It includes practices used by courts from all around the country, and there are lots of examples and also practical guidance in there so that courts can get inspired and also find practices that can be useful for them. And we'll put a link to that back in the chat. And just last, our team at Ideas 42 specializes in working with jurisdictions to redesign their communications, especially key court forms and court date reminders. We use behavioral science to help optimize those. And this is the heart of our Unwarranted initiative, where we have a goal of preventing 500,000 missed court dates over 5 years. And we'll put our contact information in the chat. We're always happy to talk with courts that are curious about how to optimize their communications. So please do reach out to us if you're interested. And just thanks so much to everyone for being interested in lowering barriers to court appearance for folks. We hope that this work and today's conversation can be a helpful resource for the field. So I will, with that, turn it back to Crystal.
Thank you, Samantha, and thank you, Alyssa, for that great presentation. It really lays the groundwork for what our esteemed guests are going to share on the panel that we have coming up right now. We have 3 guests today, and they'll be sharing about their experiences implementing a few of these innovative approaches, some of which were touched on by Alyssa and Samantha's presentation. And joining us, we have Karen Kane, Director of Court Research at the New York State Office of Court Administration. We also have Jamia Steele, Senior Public Defender at the Missouri State Public Defender's Office. And we have the Honorable Courtney Wackel, Presiding Judge of the Kansas City Municipal Court. Welcome to each of you. That was a very brief bio, but if anyone in the audience is interested in learning more about their background, we have included their bios on the event webpage, which we'll also share on the chat. Thank you all for joining me on screen. So we're going to talk about some of the approaches that you all have begun to implement in your jurisdictions to address this issue of court attendance, right? To help prevent missed court appearances and to make sure folks are better able to make their court appearance. So we want to talk about that within each of your capacities. I'm going to ask an opening question for each of you to have an opportunity. Could you offer just an introduction to the approach or program your jurisdiction has implemented, and then, talk about maybe specifically what problem or issue your jurisdiction was confronting? So we'll turn it over first to Karen Kane. And then can we have that follow up by Jamia Steele and then Judge Wackel? So
thank you very much. Okay, I'm going to share a little PowerPoint that I put together, so bear with me while I share my screen. Share. Okay. Right, well, I'm happy to be here today to talk about what we're doing in New York State. Here in New York State, our court system has a few different ways to notify litigants of future court appearances. I'll be focusing on our automated notification system, but I'll also mention a couple other methods we've implemented over the years. Sorry, gotta switch the slide. Okay. In our automated method, which is used to notify defendants of upcoming criminal court appearances, the generation of appearance reminders is fully automated and happens in the background without any manual intervention from the courts. The court's first introduction into an automated notification system was in approximately 2014-2015 as part of a research study with Ideas 42 and the Chicago Crime Lab on criminal summonses in New York City. The 18-month experiment, which involved different types of text messages and voicemail reminders, found that the most effective reminder message reduced a defendant's failure to appear by 26%, which is exactly what the Ideas 42 folks just told us. Then in 2019, we expanded our automated notification system as part of bail reform legislation. The legislation mandated that appearance reminders be sent to all defendants in criminal cases. So our office, the Office of Court Administration, oversees the notifications outside New York City, while the Criminal Justice Agency is responsible for the notifications in New York City, since they had already been doing them for many years. And we provide CJA with a daily extract of supplemental information to assist with these notifications. Notifications can be sent by email, text message, voicemail, and physical mail, with the defendant being able to provide their preference. The courts are required to check with the defendant at every court appearance as to what method of notification they want to receive. So hundreds of thousands of notifications have been sent, with the greatest volume being physical mail. And just one note, during the pandemic, we are fortunate to be able to use our automated notification system to send notification for other purposes relating to eviction, foreclosure cases, and extensions of orders of protection. I want to talk about some things to consider when designing and implementing automated notifications. Most importantly, your notifications will only be as good as your contact information. For example, the bail reform legislation requires the police, before issuing a desk appearance ticket, to inform the defendant that they may provide their contact information for the purpose of receiving a court notification to remind them of their court appearance. This contact information may include one or more phone numbers, email, and current residential address. And then any information provided is to be transmitted to the appropriate criminal court. But not surprisingly, many defendants decline to provide any of this information to the police. And we did see this in the Ideas 42 study. People were very reticent to give the police their phone numbers for the text messages or voicemail reminders. So in many instances, the court only has the defendant address that was recorded from the ID presented to the police at the time of the arrest. And this ID may not reflect their current address, and thereby increasing the likelihood of someone not receiving their initial reminders. Obviously, this is not a technology issue. The challenge is about the comfort of people providing additional contact information to the police. For those defendants who do want to receive notification, it's important to be able to provide a simple process for parties to update their contact information during or after their appearance. Our courts provide a one-page form to capture the updated contact information, as well as the preferred way to receive the court notifications. But again, we can't force defendants to provide this information. It's completely voluntary. For text messages, we're required to allow recipients to send a stop message to no longer receive the messages. So care should be taken about issuing too many reminders, which would make the recipients more likely to request a stop. Also, our courts tend to consolidate appearances for the same defendant so they can appear once for multiple cases. Our notification system uses a mechanism to deduplicate the records to avoid spamming someone with multiple notifications when cases are being heard on the same day. And then finally, if physical mail is part of your notification system, you need to be aware of the cost, as snail mail is the most costliest method. For us, it's like $1 per letter, and the letter goes out 12 days in advance, but we only send 1 letter per appearance because it's so costly. One of our other notification methods is called e-notify. And this system is directly integrated into our various court case management systems, including criminal, civil, and family court. And e-notify has 2 main purposes. It's to facilitate the transfer of case documents, and it also sends appointment reminders, including notifications of rescheduled or canceled appearances that can be integrated into both the court's own calendar and the calendars of the parties on the case. And last year, we sent about 250,000 calendar appointment notices through e-notify. And then finally, we have a self-service notification model called eTrack. This system allows anyone to sign up for free to receive email appearance reminders. It's available for almost all our court types, including criminal. There are currently about 150,000 registered users, and the email reminders go out 1, 7, 15, and 30 days before each of the appearances. And then last year, the self-service model had issued nearly 2 million appearance reminders. So those are the 3 models of notifications we use in New York State right now, with the automated model being the main way we notify defendants in our criminal courts, so that hopefully they show up and avoid being issued a warrant. Thank you. Oh, you're on mute, Crystal.
Thank you, Karen. Thank you for that overview of what New York State is doing to help people get people to court. I'd like to turn it over to Jamia Steele to talk about her efforts in St. Louis.
Thank you, Crystal. Yeah, I'm Jamia Steele, and I am here, one of the attorneys that works at the Tappan Center, which is a program out of St. Louis County in St. Louis, Missouri. It came about in March of 2020, as we all know. COVID happened. We had the stay-at-home orders, and which meant that court was closed. Everything was closed, essentially. However, the courthouse was closed, but court was still supposed to be going on. And we saw a situation where a lot of people, the court went virtual, sorry. So the court went virtual, where people would have to appear via Zoom. That eventually turned to WebEx. And the situation was a lot of people weren't able to attend court virtually because they didn't have access maybe to internet or Wi-Fi services, or didn't get notification of this virtual court date because they may have moved or didn't receive the mail, whatever it may be. So we noticed a lot of people were having warrants, but they wanted to get back re-engaged with the legal system to resolve their case in some form or fashion. So we noticed this need. So in July of 2020, conversations started to be had with the partners currently with Tappan Center, and that's the MacArthur Foundation Safety and Justice Challenge, the Bail Project, St. Louis County Prosecutor's Office, St. Louis County Libraries, and St. Louis County, Missouri State Public Defender's Office. And so we decided to come together collaboratively and start a process of being able to recall warrants in the St. Louis County area. And we came up with the name Tappan Center, so someone could tap back into the legal system. So those conversations started in July of 2020. We went live in September of 2020, and we are still working. We are based out of the St. Louis County Library in Florissant. It's every Tuesday from 6 to 8. You can either come in personally and try to request a warrant recall, or you can also call in, or you can send an email. So we're real flexible about, contact with us in order to do so. And we also chose the hours of 6 to 8, keeping in mind that people maybe work during the day, so maybe they could come later in the day to look into getting their warrant recalled. So that is the approach that's been implemented in the St. Louis County area. I don't know if many are familiar with St. Louis, but St. Louis has these sections. So it's just St. Louis County that Tappan Center really services. However, you have St. Louis City, you have St. Charles County, but also within the subset of St. Louis County, there's like 87 to 90 municipalities where they have their own little mayor, city hall, police department, things like that. So the Tappan Center, we will handle felony cases, misdemeanor cases. There's no barrier. You can come in if you have a major serious felony like an assault first or a robbery. I'm not saying you're getting that recalled, but there's no barrier as far as what type of case it is that you come in with. We also help the municipality warrants as well. So if you get a warrant in one of the municipalities like Belnor or Ferguson, as people probably have heard, you can come. We will try to help you get that warrant recalled. Also, when you come to the Tappan Center as well, we provide community resources as well. So if we get your warrant recalled and transportation is an issue, the Pell Project has stepped in. They'll help you with transportation to your court dates for future. So it's just a collaborative effort that helps with the legal system and the community as well. You're muted.
So sorry, thank you for that, Julia. Of passing it on to the Honorable Judge Courtney Wackel.
Thanks, Crystal. Hi, everyone. My name is Courtney Wackel. I was appointed to preside over our domestic violence dockets at the Kansas City Municipal Court in January of 2015. And in October of 2022, I was appointed presiding judge of our municipal court. Thank you to IDS 42 for inviting me to participate in this panel. The Kansas City Municipal Court is the largest municipal court in the state of Missouri. We have very high volume dockets. There are approximately 87,000 cases filed in 2022. And for 2023, right now, we're at about 70,000 cases. About half of those cases had failure to appears in 2022. And so the municipal court has taken several steps to try to increase our appearance rates. The first thing that we did was modify our summons that go out to people. I'm going to try to screen share so that I can show you our summons. Okay. This is our original summons that we used. You can tell but at first glance, like it really, there's really nothing that stands out except for a bunch of words. You have to look pretty close to find what the summons is saying. There is in red, at least, says ignoring the summons will result in a warrant, but it's kind of lost in whatever the summons is trying to say. So we reworked our summons, and here is what it looks like now. So much fewer words. It's very clear that it's a summons. It has some color on it. It has important in red, and there it's a lot easier to see that if you miss your court date, you're going to end up with a warrant. Also, we included on the back of the summons just some helpful directional information about how to get to our court, where do you park, how can you get more information, so that if people need to ask for a continuance or have general questions, that is on the document that they received telling them that they have a court date. So that was the first step that we took to try to improve our appearance rates. The next thing that we did was start walk-in dockets where people can just come in and ask for their warrants to be recalled. We have walk-in dockets on Monday mornings and Wednesday afternoons. And we created a policy that anyone that comes into the walk-in docket, they cannot be arrested. So it doesn't mean that we will set their warrant aside, but they can come in and ask that their warrant will be for their warrant to be set aside. And if the judge does not feel it's appropriate, then we will advise them on next steps, probably just that they need to consult with an attorney. I've also added welcoming remarks to my walk-in docket. I start my walk-in docket by introducing myself, saying my pronouns, telling the people in the courtroom that I appreciate them being there and that I appreciate their time. And that has really changed the tone of the courtroom so that people who have fear of court and who have questions about why they're there are now more willing to ask those questions, because I have started the docket in a more approachable way, a little less formal way. We have legal aid and a prosecutor that comes in at the end of the docket. So if people come in and miss their legal aid court date and want to try to resolve their case while they're there, we have created the ability for them to do that. So they can resolve their cases and they won't have to reappear, therefore not having any more failure to appears. We've added a Saturday walk-in docket. It just actually started last Saturday. So that format is a little bit different. You have to sign up for the Saturday walk-in docket, and that's just so that security that works the weekend and the judge can better prepare for who's going to be there. We use Calendly. It's a very common app for people to sign up for that. Since January of 2023, we have helped over 2,300 individuals on our walk-in dockets. And then finally, we have rebranded our court. And actually, I should probably say branded, because I don't think we really had a cohesive method for what our court stood for prior to these efforts. We created a motto: fairness, equity, and accessibility. We launched our motto at a resource fair that we held in our courthouse, where all of the community partners that the court works with were present at the resource fair, and anyone in the public could come in and see kind of what our court is about. We also launched our evening hours. It was all in a press release at the same time. So we started holding Wednesday evening dockets, where people who are hiring a lawyer can continue their case to an evening docket so they don't have to miss work. We're putting out kiosks in the community where people can they don't have to come to court to pay their fines. They can do it at a kiosk. They can also get information about their court appearances and court dates at the kiosks. And the Wednesday evening hours, our probation department is open. So if you're on supervised probation, you need to do a UA, you can't miss work, you can come on Wednesday night. And also our cashier's offices are open. And finally, we have TVs in our courtroom, mostly for presentation of evidence, right? They don't get used a lot. But we are now going to use those screens to display helpful information about what the purpose of the docket is, what the defendant's rights are, and wait times if those apply.
Thank you so much, Judge Walkle. I'd like to open up the conversation between the three of us before we get to the audience Q&A. Something that the Ideas 42 presenters Samantha and Alyssa discussed was this issue of fear that often plays into people's decisions or actions when it comes to court appearance. Could I direct a question to you, Jamia? Like, thinking about the Tappan Center, you mentioned that it's placed in the community, it's in a library, it's a place that people would access regardless of whether or not they were court involved. How does the Tappan Center address that underlying fear that Samantha and Alyssa so helpfully described earlier?
Yeah, so that was in the conversations when we first started talking about Tappan. It was, how do we make people feel comfortable coming to a location with a warrant? So the main thing was, as you said, a library that is a safe haven, I would say. And the other thing is the prosecutor that is involved with, reviewing the case to see if they'll recall the warrant. They are not on site. They are remote. So that takes away some of that fear as well. The other thing is that there is no law enforcement present. We specifically asked the St. Louis County Library to ask the officer that may normally sit on the lot to specifically not sit there on Tuesdays between 6 to 8. Again, we did not want a law enforcement vibe. We didn't want to deter anyone from coming. So we put all of those things in place. However, it is 66% remote of the warrant recall request that we get, which is expected. And of course, you know, you get people that will call and be like, can we really come? It's like, yes, please come. We put all these safeguards in so you can come and, you know, be at ease, you know, trying to get this recalled and move on.
Thank you. And Judge Walco, you touched on this a bit as well, this issue of like fear, and you described creating a policy essentially where within the walk-in docket days, individuals who come in to clear their warrant don't they can't be arrested. Could you talk about like how was that policy generated, and maybe some of the partnerships locally that needed to be tapped into, or the discussions that needed to be had to even get that policy in place?
Yeah, I think honestly, the biggest pushback was from our own bench. And our court received a grant from the National Center for States Courts. So they were telling us that our walk-in dockets would be more effective if we had this policy. And I think a lot of judges were afraid that people, for example, like compliance DV probationers who had warrants for absconding or receiving new charges, they were afraid that those type of people would use it like as a shield or something, like they would like come in and that hasn't actually been a problem at all. Sometimes I do actually take those people into custody at the end of the docket. If they sit there and wait the whole time, I'll clear everybody out. And then if they need to be into custody, we would do that at that time. But I think we put it on our website. We made it like we did that simultaneously. We were at a conference. We decided we were going to make this change. We immediately changed our website and our policy, and the numbers have gone up a lot for people coming in. And I think the people are just, I guess word of mouth is a pretty powerful thing in municipal court. And I think people are now more seeing the court as a place that wants to help them and not something that they have to be afraid of.
Yeah. And turning to Karen, I know that, you know, Judge Walco, part of your comments, you covered like a lot of different approaches in order to adjust the court appearance. And it seems like, you know, OCA in New York State has taken on like multiple approaches to get people information, right? To make sure that they stay connected to the court. Karen, could you talk about, you know, share more about OCA's multifaceted approach and how it developed specifically, and then how these options have benefited the court and those who appear before the court?
Sure. So our various notifications methods rose out of the needs of litigants, of court staff, security issues, and legislation. For example, the e-notify, there was a concern that the courts were directly emailing litigants through an unsecure environment. And also we wanted to build that notification directly into the case management system to make it more efficient for the court staff, while again assuring security. And then at that time we had that, so we were able to add the calendar reminders in. And E-Track was started to cut down on the questions to court staff and reduce foot traffic in the courts. You know, of litigants who are coming in to find out when their next court appearance date was. And our automated notification system was, as I said, the result of the 2019 bail legislation. So hopefully all our methods have reduced missed court appearances, as well as maybe reduce some stress for the litigants.
Thank you. Thank you for that. Judge Walco, would you be able to speak more to like what were the underlying concerns that your jurisdiction was trying to address? I mean, you mentioned that there was significant low court appearance rate. So what other circumstances or concerns gave rise to the warrant clearing dockets and the other efforts? And what results have you seen thus far, if any?
Yeah, I think I said about 50% of our cases had failure to appears. And because of our volume, it's very important at municipal court that we do resolve cases in a timely fashion because they keep coming, right? So we really wanted to find, clear some of these warrants. How do we get these people in here to resolve these cases? But they weren't coming in because you would come in, the first person would come up, they'd have a warrant that the judge would be like, oh, I think, your case is 10 years old or whatever, I'm going to take you into custody, and everybody would leave. So it just isn't effective. And so honestly, now that I'm making these opening remarks, the courtroom gets fuller and fuller, and people are bringing in their relatives and their friends. So we're just really, it's serving everyone because the people are afraid that they have warrants that they're going to get arrested. So I'm alleviating those fears. We're moving their case, we're resolving it and closing the case. So that's helping the court. It's just, it's a win-win. And like I said, I think that it's not been able to be used as a shield. It's only at these certain times that we can do that. We don't set aside everybody's warrants. Some people, we say we can't. Some people, like a compliance docket person who knows they have a warrant, I can tell them, this is what your warrant is for. I'm not able to set this aside. And I think it's transparency. The transparency really helps. It goes a long way.
Yeah. And Jamia, if I could ask you, how were, the necessary partnerships built among different agencies? How were they formed when you were planning the Tappan Center? And did you encounter any particularly challenging issues that needed to be resolved?
Yeah, so as I said, MacArthur Foundation and the Bail Project, they were involved in the beginning stages with Missouri State Public Defender's Office on this warrant recall process. And then, of course, we needed to get the buy-in from the prosecutor's office. And St. Louis County Library was brought in, as we said, for the location purpose. Some of the challenges, I think, were trying to figure out a location as to where people could come. So which library, would be it. So I think MacArthur actually did an analysis of the zip codes of those mostly confined in the St. Louis County Jail. And most of those zip codes were North County. So that's how we came up with the Florissant Valley branch, where the Tappan Center is currently located now. The other challenges was getting the buy-in from the prosecutor's office as well as the bench. They wanted to know more about this process, of course. What type of warrants are you going to be looking at? Tell us more about that process. So, we had a lot of conversations, but I believe that we were able to get off the ground because they saw the value of getting people back into court, getting these cases resolved. They have less cases on their docket. You satisfy the alleging victims by getting the case resolved. So everyone, kind of wins in that situation. And I think that was the reason for the buy-in for everyone eventually.
Okay. And turning to you, Karen, so were there any particular lessons learned from the studies that were conducted in partnership with Ideas 42? Jamia just mentions the Safety and Justice Challenge did some background research to find which neighborhoods people were coming from who ended up being admitted to the local jail. Were there any lessons like that, any background information you were able to obtain from that partnership with Ideas 42 that were then implemented with the text message reminders?
So we did adopt the frequency of the messages used for the study, the 7, 3, and 1 day. Also, because the consequence message, the come to court and avoid a warrant, was found to be effective in the Ideas 42 study. And because CJA, the entity in New York City that sends out the reminder notification, uses this type of message as well, OCA decided to use the consequence message, but we added in that if the person had any questions about the appearance, they should contact their attorney or their pretrial service agencies. So those are the things that we adopted from the study.
All right. That's great. That's great. Implementing sort of lessons learned. I'm sure some of that will continue to happen as you work through the implementation of these programs, learning from the experiences as you go. Leaning into that a bit, Judge Walpole, I know you mentioned you updated your court forms, right, to make them just more accessible to people. You created walk-in dockets in several days of the week, now including Saturdays. You changed your branding, you created a model for the court, and you created kiosks, right? So there's all these different approaches, I think, that your court has implemented in order to make the court more accessible in lots of different ways. Could you speak to how did that multifaceted approach come about? Why did you land on these particular solutions?
So we were already doing the walk-in dockets. I think we had only one when we've probably been doing that since before COVID, maybe 2018. The major change in that was just to change the policy of not arresting people at the docket. And that has completely opened that up and just made it more, people are more responsive to it. And that's why we created the Saturday docket as well. I think the other things we changed, the forms were prompted, and I think Karen spoke to this as well. The change in forms was prompted by change in legislation that required that forms say certain things. And so we already had to change our forms. And so then we were looking into, okay, how can we then make them more effective? We have to change them anyways. How can we make them be more clear and more effective and say what we want them to say? The kiosks and the evening, I think we've been talking about evening hours for a while. It's kind of like things that we've been talking about that once we made a few changes, we're like, well, let's just go for it. And they weren't really, it wasn't something that took a long time. It was like the concept was, how do we get more people to come to court for their court dates? And then once we had the ideas given to us by experts like you guys, then it wasn't really that hard to make the changes. And we had a lot of buy-in. I think I saw a question about the political, our city council is 100% on board with what we're doing in municipal court. And I think Missouri, I know Jamia's probably seen this in St. Louis, we are not wanting to arrest people on money owed violations. We are not what we're trying to make the changes that I think the whole legal system and political system are pushing for. So we had complete buy-in, and we had a lot of positive response from the media as well when we were trying to promote this. And I think that really helped get the word out.
Yeah, that's great. That's great. I think we can turn to some audience questions. So I want to ask, there's one question entered, acknowledging these efforts are great to effectively engage individuals in court systems and increase court appearance while reducing failures to appear. So I guess the question is, how can we influence these courts in general that may be resistant? Judge Walpole, you just mentioned that once you kind of got the ball rolling, you have the local political support, the ideas were there, but how for anyone who's in a jurisdiction where it's just they're not meeting that sort of eagerness to implement such changes, how can you influence these courts in general that might be resistant to adopt these changes?
Well, as a judge, I will say that the walk-in docket is 1,000 times more enjoyable for me to preside over now that I have made these changes. People are grateful. They want to be there. They're very appreciative. They're relieved. And so what I've done with my bench is just been like, why don't you try it? Just see what it's like to come into a room where people aren't afraid of you, where people think, that the court system is out to get them. Just that alone, that change in the environment has really made it a positive experience and something that I want to continue to do. Because it feels, we're public servants, and it feels like we are serving the public when we have that kind of openness and serving the functions that we're meant to do.
Jamil, would you have a take on this as well? What are some of the things that, how can local courts, local jurisdictions be influenced to implement some of this stuff? How do you overcome some of the lack of political will or attention to this issue in order to make something happen?
The thing is that it's really a program that helps everyone, honestly. With the Tap-In Center, we also have, we've expanded. We also have like a resource reentry fair. So, and that's like every other month on Tuesday night, the same time as Tap-In Center, where we have people there for employment opportunities, housing, school. We had WashU and SLU there. It's a program where not only can people get the warrant recalled, get back into the legal system. Again, as I said, it helps the prosecutor's office. They get the case resolved. It helps the judge. The case gets off the docket. The person that goes to the Tap-In Center for the warrant recall, they might find a job. They might go back to school, something that would, maybe not have another contact with the criminal justice system. I just think it overall, it does help. It helps everyone. But the conversations have to be made, and you have to explain that to everyone so they can see that. So it's kind of like what Judge Wackel said. It's not a hard thing to do at all. It's not like I don't know. It's just not difficult, and to me it just seems like a no-brainer to do this and get these cases resolved. That's all.
Could I ask for any one of you who may be interested in answering, and I'll invite Samantha and Alyssa as well of Ideas 42 if they have any take on this. How might courts adjust their budget in order to fund some of these initiatives? Have you encountered any of these challenges or seen any examples of courts that had to implement this and found a way to fund it?
Well, I'll just say in New York State, when you break down the costs of text reminders and voicemails and letters versus how much it costs if someone warrants and everything the cost that goes into that, it's much, much cheaper to issue these reminders. And I asked the person behind our notification system, like, how much does it cost, per month to send out text messages for us? And in New York State, we're a huge state, it's $6,000 a month for the text messages. The letters are a little more pricey. They're $64,000 a month. But if you add all that up, it's probably a lot less than, I think, Alyssa, maybe you said it was $11,000 per missed warrant. So if in New York State, there's a lot of outstanding warrants, especially in summons cases. There's like 1.5 million warrants outstanding right now. So I don't think it's a hard sell from an economical point of view.
Yeah, thank you.
But we're a big state. We're a unified court system, so I know we're different.
I wanted to ask of Jamia, this is a question I think for you. If an individual comes into the tap-in center and the warrant isn't recalled, I'm sorry, will they go to jail on their warrant at that time, or what's the follow-up procedure there?
They will not. So again, at the tap-in center location, there is no prosecutor on site and there's no law enforcement there. So if you come in and I contact the prosecutor and they say, Jamia, I can't agree to recall it, you go home. You get back in your car, you go home. Sometimes I will suggest to them maybe reach out to an attorney, because most of the people that come to the tap-in center think the data is 80% don't have a lawyer. So while they're there, they can apply for a public defender. So if they get approved for a public defender, I tell them, see if their attorney can maybe get it recalled. And there have been other times too where I just maybe will go to the judge myself and see if they'll do it. If the prosecutor won't agree, especially if it's something low level, like a traffic ticket or something, like seriously. But no, you go home and try it another way.
Okay. And moving along, we have quite a few questions from the audience. So thank you all for your participation and interest in this topic. For Judge Wackel, from what you've seen, how widespread are the practices you're describing? Have you connected either within Missouri or outside? Have you connected with other judges who are thinking about or implementing these types of strategies?
Well, I've met a lot of judges working on implementing these types of strategies through the National Center. None of them are local. But the municipal court in Kansas City is a little unique in that we have court Monday through Friday. It's an all day, like we're always open. A lot of the municipalities in this area are open like only one night a week, or so it's a little bit different from that perspective. But I do think this is a change in how courts operate. But like Jamia said, like we want these cases to be resolved. And fear is proven, right? Statistically, it's not an effective way of getting people to resolve their cases. So I think this is the trend of where things are going, but I haven't seen a lot of it where I am.
Okay.
And Crystal, can I just add that in New York State, just so you know, we've had a number of warrant clearing events. We could, on a Saturday, and it's a little difficult to organize the whole thing and get letters out to the defendants about coming to the event and everything. But we in New York have been doing warrant clearing events for a long time. And sometimes we do, we are able to, when there's bulk dismissals because of, a policy by the district attorneys to no longer prosecute certain low-level types of cases, there's a lot of warrants associated with those cases, so they get closed along the way as well. So in addition to our notification system, we have a lot of ways that we've tried to clean up the warrants in New York.
Yeah, thank you for that, Karen. Could I ask a question about disparities? So I'm wondering, in terms of with the tap-in center and with the walk-in dockets, there's like a very in-person aspect of that approach. Is there any way you have seen racial disparities being impacted, or you can anticipate? A lot of these implementing are, some of them are in different stages of implementation and progress. Can you imagine there being some impact on racial disparities? Sorry, I think I was directing that towards me or Judge Wackel or whoever.
I can answer real quick. So this is what I can tell you from the data we have. To date, we've cleared 860 warrants, and 74% of those warrants recalled were African American. Recently, just to give you context with that, our jail in St. Louis County holds a maximum of 1,300 people. Currently, it's 1,034 that are currently in the jail. Of that numbers for C, D, and E felonies, 65% of that population is African American. So how this correlates is we are essentially trying to keep African Americans out of jail. I mean, those numbers just kind of blow my mind when you say it out loud. I mean, reading it is enough, but saying it out loud, the disparity is shocking and appalling. But I'm proud of the work that we're doing to keep, African Americans from being detained, and possibly, losing their jobs, cars, housing, whatever it is, and they can engage back in the legal system outside of jail, especially on low-level cases.
Yeah. And Karen, turning to you, I believe there was a finding regarding wealth-based disparities within the Ideas 42 study. Could you share a little bit about what was found and how that may have been addressed?
Well, I'm not quite sure about the Ideas 42 study from a while ago, but what I'd like to say about trying to determine the impact of court notifications in New York, it's difficult because at the same time the notifications went into effect, the legislation required expanded use of desk appearance tickets, which we all know also impact failure to appears. And at the same time, there was a change to the way warrants were issued, requiring the 48-hour stay that was mentioned. And while the New York City courts marked these as a stay, outside New York City, the practice was to adjourn the cases without marking them as stayed. Then there were all the changes to the bail requirements. And finally, there was COVID and the court stopped issuing the warrants. So in terms of like unpacking the impact of the court notifications on failure to appear and on racial disparities, there's a lot of compounding factors at play. And it's a challenge, it's going to be a challenge for researchers to figure out what's what. So I know that, there's a lot of interest, but the data right now is just all over the place because of all those things I just mentioned.
Yeah, so some of the analysis and initial and actual impact will take time to see, right? Like how is this actually impacting those who are coming to court, or hopefully the individuals who are avoiding pretrial detention. I thank you, Alyssa, for joining us on screen. Could I direct a question to you as well? I know you all have done a lot of work, or did you want to respond to something specific?
I'm happy to. I'm also happy to jump in the other question. What I was going to say is there are two really interesting studies. Our study was able to show that people in the bottom 20% of wealth were doubly benefited from having reminders. And it makes sense if you think about scarcity. That extra support is really helpful. And these are folks who are least likely to have private lawyers ahead of their arraignment and other dates. There's also a study that CJA did with live call reminders that was able to look at differential impacts by race. And again, they saw double the impact among Black and Hispanic individuals, was classified by the census data compared to white individuals. So, we're continuing to study this in all the work we're doing with other jurisdictions, but so far the data is pretty compelling that the impact is greatest among those who are often the most impacted and affected by the system.
Thank you. Thank you for that. We're coming toward the end of our program, and I really am grateful for all the thoughts you all have shared. A few themes is that I'm hearing emerge is some of what I'm hearing, at least from Judge Paul Koljabi, is this wasn't that hard, right? It was just looking at the problem, seeing the results as they're currently happening, and then sort of meeting the moment, right? Finding the solution that works right for all of you. And particularly given what Alyssa just highlighted, right? That this has the potential to impact individuals who are disproportionately affected by the criminal justice system, and marginalized in other ways, right? Facing either racial disparate outcomes, facing socioeconomic disparities as well. So I thank you all for taking the time to highlight these issues and highlight your efforts and discuss how you landed on the solutions that you landed on. And I'm grateful for your time. And thank you to the audience as well for joining and engaging in this topic, as well as sending in your questions. We had great support from obviously our colleagues at Ideas 42, as well as other organizations who helped amplify this event. So we're very grateful for that support. So we will be leaving a slide up with information, contact information for both the Data Collaborative for Justice, as well as Ideas 42, so that you can reach us via email if there's any other questions or follow-up you would be interested for today's program. And also, we will be adding resources to the event webpage. So the event webpage was shared earlier in the event. If there's anything you are curious about to see the slides or anything like that, please check back in with us, check our event webpage, and we hope to be able to share more information with you all, the audience. Thank you for joining us. And thank you again to our guest speakers. We really appreciate your time. Have a great day.
Thank you.
Thank you.